In this time of worldwide crisis, tragedy, and suffering, it's well to find humor wherever we can. And as we all know, humor very often is nothing more than laughing at somebody else's misfortune. And so it is in bankruptcy. Every once in a while, we run across opinions that don't intend to be humorous, but when you look at them from afar, they really are. Both of these are stories that we are going to report in my column on ABI's website, Rochelle's Daily Wire. The first of them comes from a district judge in Washington, D.C. There, we had a law firm that was very successful in prosecuting a Freedom of Information suit, and as a result, was entitled to recover its attorney's fees from the government. But guess what? The lawyers did not want to publicly file their time records. I guess they didn't want the world to know either how much or how little they charged. Well, the district judge denied the sealing motion, and in large part, he was persuaded because that very same law firm, in a number of bankruptcy cases, had turned over all of their time records showing how much everybody charged. Well, that was number one case, and as you can imagine, I suppose, that the FOIA lawyers were a little bit upset at their bankruptcy colleagues, but, that's life. In bankruptcy, we know we have to tell the world how much we charge, embarrassing though it may be in some cases. Well, the second case comes from the pen of bankruptcy judge Kimball Mosier in Salt Lake City. And this case is about a nightmare that I know all of us have had, and I too, for that matter. The only way you will not have had that nightmare is if you have never dealt with that crotchety old PACER system for filing documents electronically with the bankruptcy court. I think you know where I'm going, because it's a story of a lawyer who waited until 20 minutes before the filing deadline to file a complaint objecting to discharge and dischargeability. Well, this lawyer was not terribly familiar, if at all, with the PACER system, and so he could not get the complaint filed. After basically using a trial and error approach, 16 minutes after the deadline, he finally succeeded in getting the complaint through the PACER system. But Judge Mosier threw out the complaint, saying it was untimely. Judge Mosier basically didn't have a lot of sympathy for this poor lawyer, but you can imagine the horror that was going through that lawyer's mind that night when he was trying unsuccessfully to file a complaint. Judge Mosier ends his opinion with the following, and I quote, "The PACER system may be confusing in some respects, but that is why courts around the country offer training. The court will not accept counsel's unfamiliarity with PACER as an excuse for missing a filing deadline." And so it is. Your nightmare may not be so unjustified. And I guess what Judge Mosier teaches us is two things. Don't let filing wait until the last minute. And if you're in a bind, call in somebody who knows that terrible old PACER system. I am Bill Rochelle, the editor-at-large for American Bankruptcy Institute. I will return sometime next week, either with tragedy or comedy. We'll have to wait and find out which. Good day.